There we
Yeah,
go.
now we are.
There we go. Hi, Seth.
Hello, Mr. Wright.
And if you are watching this live, hello. We are glad you are here. Don't forget, you can ask us questions, on the platform wherever you are, Facebook, LinkedIn, YouTube. Ask us those questions. They'll come right in to us, and we will answer them promptly. That's all I have to say about that. Here we go. Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. There once was a toaster named Clyde, whose marriage was quite a rough ride. His mate burned the bread, so he sadly said, "I'm done. Let the judges decide."
Welcome to the show, everybody. I'm Seth Nelson, and as always, I'm here with my good friend Pete Wright. Pete, you outdid me on the intro because I was going to throw some stuff in here, but I'm still going to try. But everyone would vote for you on that great poem. All rise. The Honorable Andy Nelson, no relation, is presiding. As we all know, Andy is our producer, and he is the one that shall not be named or spoken to. But he's like a judge. He's going to sit on the bench and not say anything and just listen. Just listen to the testimony. Judges do say stuff, but we'll get to that in a minute. So today on the show, we're stepping into the courtroom. If you've ever wondered what really happens when a divorce case goes to trial, how the strategies unfold, how momentum builds, and how the best attorneys adapt on the fly, thinking on your feet, this two-part episode is for you.
True, two-parter, unprecedented. Let's start, Seth, with the big picture. If I were to step into a Florida divorce courtroom today, what would I see? Walk me through the mechanics, the players involved, the rules, unspoken or not, the pacing. What am I going to see?
They're small courtrooms. So I'm going to give the physical layout of the courtroom because a lot of our
Please.
people and listeners only have, seen courtrooms on TV or movies. It's usually a small courtroom. And there will be the judge up on the bench, which may or may not be an elevated bench, or if elevated, just slightly. So
Okay.
you're usually looking either eye level or up to the judge. Then there will be two counsel tables where the lawyers sit. One lawyer at one table, the other lawyer on the other table. The lawyers usually sit closest to each other. And
To
then
keep their clients from
then the
having to be
parties
close to each other.
sit to the opposite sides.
Is there
Okay.
always a side for uh, like defendant, and what,
It is
is
such a
there
great
always a
question.
side?
It's
Yeah.
such a great question. So there in family law, it's a petitioner and a respondent.
Okay.
Okay. In a civil case where let's say you were suing me for breach of contract, it would be a plaintiff and a defendant.
Hmm.
Okay. Or the state and the defendant. In law school, all
Can
of
I
us
just tell you what I
lawyers.
imagine first?
Yeah, go
I
ahead.
imagine like you just get to court early and run to get the best seat. That's what I
yeah,
imagine. That it's
yeah.
a race. It's a
That that
goddamn race.
that is not what happens. I assure you. I do get to court early. Other than that, everything else is false. um, so when we're taught in taking notes, we always start with plaintiff versus defendant, which we have a like shorthand for, right? So
Mhm.
plaintiff is always on the left side of the page, and defendant is always on the right side of the page, and that's kind of how you view the world. So in the courtroom, this is very funny you asked this question because in the courtroom, I haven't thought of this in years. Usually, if you're facing the judge, the plaintiff will be on the right and the defendant will be on the left, or petitioner will be on the right, defendant on the left, because when the
Because it's
judge is
judge's
looking at you,
rules.
it's when the judge is looking at you, it
Yeah.
is reversed, right?
That's stage
So
rules too,
that
right?
that
Like stage right, stage left. It's the
that
same thing.
is same thing. Same
Yeah.
thing. It's very
Okay.
funny that you asked that. Okay. So you come in, you sit down, and this is one of my favorite things in the law. I don't care how much of a hotshot lawyer you think you are, or maybe you are a hotshot lawyer in top of your game. At the end of the day, when you're in that courtroom and you're sitting waiting for trial, you're like everybody else. You're waiting on the judge. The judge is in control. Okay.
Okay.
Now, judges have personalities, and some have more kind of authority they all have the same amount of authority, but some judges have different demeanors on the bench, and they will exert their authority much more quickly than others. Some judges will let lawyers, quote unquote, get away with stuff that they maybe shouldn't. Maybe they'll let them go on too long, or X, Y, and Z. So it really depends on the judge. A lot is controlled by the judge. They have a lot of discretion and a lot of power to run their courtroom the way they want to run their courtroom. So you have that layout. There's probably some benches in the back, like pews.
Mm-hmm.
Anybody in the public can come sit in on your divorce case as long as they're not a minor.
Okay.
Okay? And
What is the value of that?
Of telling people that is like literally no one ever comes.
I can't, like, all due respect, I can't imagine wanting to come sit in on somebody else's divorce trial. I can't fathom
right.
that.
Now, there are rare circumstances where people come. It might be people from the law office are like, hey, I want to see the opening. Or you might have a friend that's there to support you, which I try to encourage, don't come in the courtroom.
Mm-hmm.
But then you might want to bring your parents or other people, or you might want to bring some of the witnesses in the courtroom. And this is something that we'll get to, or we'll just deal with it now, I guess. The witnesses are not allowed to be in the courtroom unless they're an expert to listen to anyone else's testimony. It's called invoking the rule. And there's all these little sayings that I just love because I'm a law nerd, right? But so there's the benches back there. There's the bailiff, right?
Bailiff is sitting up in front.
Well, he will usually be sitting by the door.
Oh, okay.
Okay. And remember, you have your from the back to the front, you have the benches, you'll have a half wall, and then you'll have the chairs for the counsel table, then you'll have a space, then you'll have the bench. And next to the bench, there's usually two chairs one on each side, one for the witness and one for a court reporter.
Okay.
And then by the door, there's usually a chair with a little table where the security officer, the bailiff, the sheriff's officer sits because they're assigned to protect the court. Okay. That bailiff will always be in that courtroom if that judge is in that courtroom.
Okay.
Okay. So there's some rules of the road. You, as the client, should be asking your lawyer, where do I sit? And you should know before you walk in. So you go in, you sit down, you get out your pad of paper, you get out a pen, you don't bring any other notes with you, and you flip over a couple pages, and you can write your notes on anything you want to write during the trial a couple pages in. Because when you're done writing, or if it's a break, you literally take the first couple pages with nothing on it and put them down so no one can see your notes.
What about devices, iPads? What if you want to write on a digital tablet?
Not coming in. Turn everything off. And I don't mean silent. I mean off. There is nothing you're going to answer at that time. If someone needs to get a hold of you, make plans to call the lawyer's office and have the lawyer's office contact the lawyer. But you're not answering your phone. You're not checking your phone. You're not looking for text. You're not getting the latest sports scores.
Well, honestly, I was just thinking about using my Apple Pencil on my iPad to take notes. That's my normal thing. I don't use paper really, so that's just you
I don't
frown
want
on
it
that.
because I frown on it. I would tell you, nope, you're using a pad of paper because I don't want that thing dinging and distracting you and whatever.
Sure. Okay.
That's the layout of the courtroom. Go ahead.
Yeah, let's talk about the processional. I'm going to call it the processional, like a wedding.
Yeah.
When the judge comes in and what do I expect if I'm sitting next to you at that counsel table?
That's exactly where I was going. The bailiff will come in first. He might be there and be like, are you all ready for the judge? Yes. Then he'll go get the judge. And there's a door past like where the bench is. So we come in from the public area. The judge comes in from a secure area.
Is that a judge's like quarters, hair and makeup, chambers?
Yeah.
Okay.
Chambers.
So
and back there is a long hallway with a bunch of offices that are called chambers.
And that's where the judge's permanent office is.
That's correct.
Okay. So is a judge assigned their own courtroom?
Yes.
that's associated with their chambers?
Well, it is. Yeah.
Chamber?
Well, yes, it's all by seniority.
Okay.
So judges get to pick their courtrooms based on the court that they're on by seniority, and they also get to pick their chambers by seniority.
Okay. So there isn't like a rotating, like there is a docket that judges get assigned cases. You don't get assigned a courtroom. You
get
have your
assi-
courtroom.
You have your
It's
courtroom. You got it.
fixed. Okay.
Yeah.
All right.
Okay. That you have it all set up the way you want it set up and
Yeah.
all that stuff. Okay.
All right.
Your computers, your email comes to it, the whole thing. So
Yeah.
then what happens is the bailiff comes in and he's going to say, all rise, which means you stand up.
Okay.
Let's
If there
be
was any
clear.
confusion, put the
Let's be clear.
Twizzlers down and
That's
stand
right.
up.
That's right. People get nervous. Okay.
Yeah.
And then you wait for the court to say you may be seated and you stand until they do. And sometimes judges are coming in and they're thinking about not your hearing, but they just ruled on 3 emergency motions and maybe they're thinking, okay, about that. And they sit down and they start getting their stuff together and they're not ignoring you or being rude. They're working, but they kind of forget everyone's standing. They look up and like, oh, I'm sorry, take your seat. Okay. And sometimes right when they walk in, they say, you may be seated. Okay. And then you sit there quietly and wait. You don't say anything other than if the judge says good morning, you say good morning. Or you might say good morning, Your Honor. You might say good morning. And then you wait for him to tell you what we're about to do next.
Okay. How prepared is the judge on walking in to the courtroom? Have they reviewed the factors of your case? Or do they just wait for you, the attorneys, to give it to them?
Well, that is a great question as well, man. Pete, you're crushing it. We might need to turn this into 3 or 4 episodes.
Okay, I'll shut up is what I hear.
No, it's great. These are great. So, a judge would have already reviewed, you hope, it's stuff that's been submitted, like a pretrial memorandum of law that the judge ordered you to file. Hopefully, they've reviewed it. They might have required a memorandum of law, which is different than a pretrial memo. A pretrial is kind of basic, like here's what I'm asking for, here's the issues. A memorandum of law is like here it is, judge. Here's what we're going to prove. Here's the law you have to consider, and the case law and cites and when people say, oh, I wrote a brief, or a memorandum of law. Technically, they're different. Briefs are appellate court, memorandum of laws are trial court, but the concept is the same. You're explaining to the judge what is the issue, what are the rules, what are your analysis of that compared to the facts, and what the conclusion should be for each issue.
Okay.
Okay.
You said hopefully the judge has reviewed that.
Yeah, hopefully. Now, they don't necessarily have to review it at that time, because it would be great if they did, and I have a lot of good judges now, and a lot of them will read those. Okay. The more experienced the judge is, the quicker they read it because they know it. Right.
Sure.
So, but regarding evidence, the judge might not looked at anything except if you've already submitted joint stipulated exhibits.
Okay.
Because the
Explain
judge
what that is.
The judge can only consider evidence, things that are in evidence. So we'll just take 3 bank statements, for example. Okay. We have husband's bank statement, wife's bank statement, and there's a trust in this case, and the trust has a bank statement. And we all agree that the wife's bank statement can come in. And we file, because the court requires us to submit before trial a joint exhibit notebook that says this, whatever we're agreeing comes into evidence is in. We're not going to waste the time and having to authenticate it and all these other things. Then the judge wants to know, well, Mr. Nelson, what documents do you want to put into evidence that the other side doesn't agree to?
Okay.
And I'll be like, look, here's my list. They didn't agree. Then they'll say, okay, well, Mr. Nelson, did they have documents that they wanted in? I'll be like, yes. Did you agree to them all? No. Remember, I said 3 bank statements.
Hmm.
The bank statement of the wife in my hypothetical, it's in. We stipulated to it
Jointly stipulated. I
jointly.
get that.
You
Okay.
both have to agree. And once
Hmm.
it's in, I'm okay if the judge reviews that before the trial starts because
Hmm.
the moment the trial starts, we're going to say, Judge, as you know, we stipulated to this. It's in evidence. Great. And the judge might say, I've already reviewed it because you stipulated to it.
Saves time.
Right. Saves time.
Okay.
He's prepared. She's prepared.
Hmm.
So then what you don't do.
Looks like we've got technical difficulties. I thought it was me. It's not. It was Seth. Oh, thank goodness it was the attorney. That's a relief. So we wait. Let's see. Oh,
You're back.
hi.
Okay.
Oh,
I told
hi.
everyone live that you guys went away on me.
And
And
it turns
so,
out you were the one who left.
yeah, I told them I was just going to
Andy and
log
I
back
were
in.
fine.
I couldn't see either one of you. It was very strange.
That was
Okay.
very strange.
So what we do here is the judge might have reviewed that evidence, Pete, because it was
Yes.
stipulated. And what the judge does not do next is he does not say, well, Mr. Nelson, you've got 20 documents that you want to get into evidence. Let's discuss each one and see whether I'm going to let it in. That's not how it works.
Okay.
And he doesn't go to the other side. We're going to discuss your 30 documents and see if they get in.
But
Those
what if you
documents,
feel really, really strongly about it?
I will still have a chance, but I have to get them in what's called through a witness.
Okay.
When I call the witness, then I will argue to get them in.
Okay.
Okay. So remember, I said we had 3 documents. So let's say they call their first witness and they go to enter a bank statement. Now, look, I already let the wife's in. I stipulated to it. So, Mr. Nelson, what's wrong with the husband? I say, Judge, it hasn't been authenticated.
Okay.
And there's certain questions that you have to ask to authenticate a document. And if it's a bank statement, technically, you need to get a bank representative to come in there and say, this is our business record. It's kept contemporaneously when it's created. We store it. This is our logo on it. Yes, this is a authentic bank statement from Bank of America.
So is there a presumption there that anything that is joint stipulated, that first bank statement, that was authenticated to both of your satisfaction? Or can you
Yes,
say, we agree to that, even if it wasn't authenticated, we believe in it enough?
that's correct. Once it's stipulated to, the judge does not care. It's in evidence.
Yeah. Okay.
Now, the second one, if they call the records custodian, then that's coming in. But I've had documents that were fraudulent. And my whole argument is it's a fraudulent document and therefore it cannot be properly authenticated and therefore it's not coming in.
Right. Okay.
Okay. Rare, but I just wanted to lay out that you have these evidentiary issues. Okay.
Sure. Sure.
And then we have the trust one. And maybe the trust one, the Bank Tampa comes in and says, it's authentic. It's the real deal. And I say, Judge, I agree it's authentic. It's not relevant. And
Okay.
because this document isn't relevant, then it should not be admitted.
Okay.
Okay. Then think of evidence as a three-legged stool. Authentic, relevant, and admissible. Okay?
Okay. Admissible, by admissible, we mean
Under the rules of evidence.
under the rules of evidence. It's been authenticated, whatever it takes to
Right.
be
Right.
admissible. Okay.
So it's not admissible because it is a confidential document. Someone has privacy rights. That is a trust document, but it's not a trust relevant or that is about this case.
Okay. So you're saying somebody might be represented in that trust that is not a party to this case.
Right. And then maybe
Okay.
it's not relevant and it's confidential.
Yeah.
Right. There could be
Okay.
multiple things. Or maybe a child's mental health record is relevant and it's authentic, but it's confidential because they have a patient child privilege
Yeah.
going on with the doctor. Right.
Right.
So just there's those three things. You have to get all three of them in or the stool doesn't stand and it doesn't come into
Okay.
evidence. Okay. So judge comes in, all rise. Let's get started. Any housekeeping issues? Yes, judge. We have a joint exhibit notebook that we previously submitted, and just you have your court reporter sitting up there transcribing everything. Make sure you order your court reporter. The court does not provide one for you, and you're going. And then what you do is you say, and here are the following documents that are being admitted into evidence. And you read, number one, wife's financial affidavit dated January 1st, 2025. Number two, and I read the list, right? Because now it's in the transcript, right? And the judge will say, counsel, do you agree? And sometimes you'll go through the whole list, and the judge will look at my opposing counsel and say, ma'am, do you agree? Yes, Your Honor, I agree that 1 through 36 are entered by stipulation. Then the judge will say on the record, I'm entering into evidence numbers 1 through 36 by stipulation, and then you'll hear stamp, 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 stamp.
36 times.
It may be. Now, they might be doing it electronically now.
Yeah.
But yes.
Okay.
That's an evidence. The judge can consider it.
Okay.
Any other housekeeping issues? Well, what are housekeeping issues? That's procedural stuff within the court. It might be, yeah, Judge, I know we're set for trial today from 9 to 5. I'm just asking, when do you typically take your lunch break? And the judge might say, typically around 12 to 1, but let's see how it goes with the evidence. We don't want to split up a witness. Let's find a good time to break, a little early, a little late. Do you have anything else? And opposing counsel might say, Judge, I know we're in trial here, but down 2 doors down, I got ordered to be at a case management conference at 3:30. So could we take a comfort break at 3:30 for 10 minutes if possible? Like anything that might have come up.
Okay.
Right?
So the judge tries to account for the fact that you're pulled in a lot of different directions.
Yeah, it's very rare to ask to leave a trial.
Yeah.
But if it's their colleague down the hall,
Yeah.
and you're asking for 10 minutes and you're going to take breaks along the way,
Okay.
they're usually very accommodating to the best that they can be.
Can I ask a question related to that, which we didn't talk about? If there are kids involved in the case, are the kids here during this, or are they treated like a witness?
The kids should never be in the courtroom, should never even come to the courthouse.
Okay.
Unless there's a court order, and usually have to file a motion for that. Do not bring them to the courtroom. Do not bring them to the courthouse. Okay?
Okay.
Great question. So now you're doing these housekeeping issues, and sometimes the judge has a housekeeping issue. And maybe the trial started at 9 and the judge walks in at 9:45. And you're a hotshot lawyer and you're waiting for 45 minutes, billing your client, right? Pays by your time. It's not your fault, right? And that you're waiting. And the judge goes, sorry, I had 2 emergency hearings that I had to cover. Right? And the judge doesn't have to explain why. So the judge can just take the bench and not say anything. They usually explain. They're good people on the bench. So once you go through housekeeping, and it might be, Your Honor, here's the witnesses we're intending on calling today, but counsel and I have agreed that we're going to take a witness out of order, even though they get to put on their case first. We have an expert, but the expert's only available this morning, and we have a stipulation that I'm going to put on the expert first, who's expensive. We can get him here, get the testimony you need to make your decision, and then they can be excused. So you might take witnesses out of what might be the procedural order differently.
Okay.
So these housekeeping issues, let's say it's 9 o'clock, it's supposed to start. You're ready there at 8:45, sitting in the courtroom. Judge walks in right on time, and then you do housekeeping issues that take, 10, 20, 30 minutes. It's now 9:30. You take lunch at noon, 10:30,
Yeah.
11:30, 2.5 hours.
Yeah. That's not a lot of time.
Trials go fast. That's my point on that.
Okay.
We only get 2.5 hours before lunch, and we get back at 1, and maybe we're going to 5. That's 4 hours, but we probably have a couple breaks in there, and the judge might have something that comes in on another case, and you might only get 3 hours then.
Okay. So what is your expectation when you walk in the morning? Is your expectation usually by the end of the day, we'd like to have this resolved, or do you know this is going to take multiple days?
You will already have that in the pretrial order and how many
Okay.
days you're going to be in trial.
Okay.
So literally, just today, I'm set for trial. There you are.
Literally just today. Nope. And gone again. It's all right. We'll get through it. I feel good. I feel good. I think he'll be back.
I'm here. I didn't go
There you
anywhere.
go.
Okay.
Literally just today.
Yeah, literally just today, a judge sent an email and said, "I know you're set for trial on next Friday. It's Thursday, so not tomorrow, but a week from tomorrow."
Mhm.
And he says, "I'm really sorry. This was set with a different judge before I got on this bench, and I have a conflict in the afternoon. I only can hear your case from 9 to 12. I'm happy to start at 8. Can we get this case done from 8 to 12?" And both lawyers said no. Probably said it a little nicer than that. And the judge was very accommodating. "Well, can we do another half day?" And we were very fortunate. We got another half day just the following Friday. Very
Okay.
lucky. Very
Okay.
lucky. But the judge was very apologetic, and we were all working together. We want to do what's best for the clients and get the case tried. We're ready to go. It's a lot of expense to redo it. Okay. So, no, Pete, we hope to get trials done in a day. And the more you can stipulate to on facts or evidence prior to walking in that first day, the quicker it goes.
Yeah.
The
Okay.
more narrow the issues. But you've heard about all the potential witnesses, right? That we might have.
Yeah.
So you do all of this preliminary stuff, trials go quick, and here we are. And then the judge says, "Okay, anything else?" "No." "All right, let's begin. And let's say that I'm going first because I'm the petitioner. Petitioner goes first, respondent goes second, and say, "Mr. Nelson, would you like to make an opening statement?" And now I make my opening statement.
Now where I understand what's going on because I've watched TV.
There you go. They
Mhm.
usually don't do those preliminary matters. They get straight to opening statements.
Yes, they do.
Okay. Everything I say is not in evidence. It is an opening statement. There is no witness on the stand. It's just me telling the judge what I believe the evidence will show.
Just attempting to sway the judge preemptively toward your side.
I wouldn't say sway the judge. I would say I'm trying to tell the judge, this is what you need to look for because these are the facts that are important. And you're not arguing the law here, and you're not arguing the case law and how the facts apply to the law. You're saying, "Judge, I'm asking for my client to get the house, and here's the evidence that will show why she should have the house." And you go through your list that, X, the husband, that will show that the evidence will show that he doesn't want the house, even though he'll
Right.
claim he does.
Right.
We will show you emails and text messages where he says, "You can always have the house. I know it's important to you, and I know it's best for the kids for you to stay in that house." right? So that's not an evidence. If I don't prove that, I just told the judge I'm going to show him something. If I don't show it, I got a problem.
Yes.
Right.
Okay.
So
Right.
you're just trying to say, here's the important things to look at. Here's what I think the facts will show. And here's, at the end, you're going to rule in my favor. That's the only logical conclusion.
Okay.
The other side then gets to do their opening. And they're going to say, the house should be sold. I agree with everything Mr. Nelson said. My client said he would love for her to keep the house. It would be best for the children. But what Mr. Nelson didn't tell you is she can't afford it. And
Sure.
judge, as you know, when people get divorced and they have the same incomes and there has to be two houses, something's got to give. And unfortunately, the house is what has to go in this case.
Yeah.
Right? So notice, he didn't even disagree with me.
No, that was a sleight of hand because your expectation is he's going to attack what you just said.
That's
and
right.
He didn't. He bobbed and
didn't.
weaved.
Exactly. And I didn't mention that she could afford the house. So I'm doing this in kind of shorthand here.
Yeah, of course.
Right? So that's just an example of what might happen in an opening when it's done well. You're going to tell the judge what the evidence is going to tell them. Big picture.
Mm-hmm.
You then, in your
Stand by. Do, 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 do. He'll come back. I know he'll come back. I should have some sort of an act ready, right, Andy? Like I should have some juggling. Is there some juggling I can do? Oh, now he's gone completely. All right. We can do this. Maybe something involving fire. Oh, did he just? Oh, he's back. Something's changed.
It kicked me out and brought me back in.
Well, it's good to see you.
Okay.
I was about to start showing off things on my desk.
Sorry we're having trouble today if you're live. Okay, what was the last thing you heard, Pete?
I think we're transitioning into after opening statements. We just opening stated. And we're moving into you're muted. Muted.
The opening statement, you're telling the judge what the evidence will show.
Hold on. Your mic is not your audio source.
Man, it's just struggling today. Okay, we good?
Yeah, that's it.
Okay, so opening statements, we're telling the judge what we think the evidence will show and why they should rule for us, not the law.
Right.
Second is the evidence that gets presented. I get to put on my case in chief, where I put on all my witnesses. I ask a question of a witness. They do cross-examine of the witness. I do redirect.
So every witness gets a threefer.
That's right.
Right. Okay.
That's right.
And that's
Direct,
the last
cross,
time you're
redirect.
that's the last time you're gonna see that witness, right? They don't.
Not necessarily.
Oh.
If I
okay.
call my client in my case in chief,
Mm-hmm.
I ask direct questions. Opposing counsel asks cross-examination. I do redirect. Witness is excused. As far as off the stand, they're not released from the courtroom. One, it's a party. They're going to be there. But then when I finish my case and I say I rest, and then they go to the other side and the judge says, call your first witness, they can call my client.
Okay.
It's on the witness list.
Okay. All right.
On the witness list.
And you'll know up front if that's going to be an option for them.
Well, it will be an option. Whether they do it or not is another story. That's up to them.
Okay.
Okay. So you go through all the witnesses, then you rest your case, then the other side puts on their case.
Got it.
Okay. And then you do all of that, and then you go to closing statements. And in closing statements, you tell the judge what you think the judge heard in evidence.
Okay.
And
I'm sure judges love that.
yes, they do. And then you weave in the law. This is where you can make your legal arguments and cite case law.
Okay.
Say, Judge, here's the law in the house. She can't afford it. You heard the evidence that she's already gotten a mortgage pre-approvement letter, and the mortgage company came in and said, Judge, we will sign this document today and give her the mortgage. And there's equity of $100,000, so she owes him $50,000, and we have a retirement account that is a Roth IRA that will not be taxed, that is available to the parties today because they're retirement age, and it has $100,000. He can have the other $50,000, right?
Yeah.
So that's how you handle closing, and the case law says you can do that, and you cite to the case, and you cite to the statute, and you cite to the rules. And you put on this brilliant closing argument where you bring it all together. Okay. I know we're only at the very beginning of explaining how the process works, but let me explain my concept here.
Okay.
There's really two things to end with on this show for part one, and we might have to go a few parts like we said. One, you're always putting pieces to a puzzle together for the judge to get a picture. It's a jigsaw puzzle. And as you know, Pete, you do not need to have every single piece for the human mind to figure out the picture.
Right.
Okay? So you get as many of those pieces into evidence, and at the end, you bring it all together. And you say, this is the picture you just saw.
Okay.
Okay. That's how that works. Go ahead. I see the brain.
No. You know what the next thing I wanted to talk about is the over the course of trial, the chess match that you're playing, right? The whole idea of building momentum and winning and losing points, because you started this podcast years ago with you as a client never get your day in court. You as the attorney get your day in court. I want to hear about that. And it sounds like that's a tease for next time.
It is, but I'm going to end with this because I swear I did not write these questions for you, Pete. This is a perfect question. The other thing I wanted to end with is, yes, it is a chess match, which we will talk about. But I want you to think first it's a tennis match.
Okay.
And we all know in tennis, they have a crazy scoring system, right?
Yeah, it's bonkers.
You don't have to win every point in a tennis match to win the match. You don't have to win every game in a tennis match to win the match.
Right.
And you don't even have to win every set in a tennis match to win the match. In women's tennis, you have to win 2 out of 3 sets. In men's tennis, it's 3 out of 5 sets. And in a tennis match, there'll be momentum shifts.
Sure.
And you'll be feeling good. And you might want to won a game on your serve. You might have broke the other opponent's serve and won the third game on your serve, and you're up 3-love, man, and you are on fire. And the momentum's going your way. And then you have a stumble. Maybe an unforced error. You were thinking ahead, and the momentum will shift, and they'll win some points. That's the same thing that happens in a courtroom, and it can change on a dime. But you can't get caught up in the momentum shifts. You got to keep, in my hypothetical and my analogy, playing the game, because the courtroom is not a game to be played. But this is playing that tennis match. You're on to the next point. In court, you're on to the next question. You're on to the next witness. You recover. And if it's a 2-day trial, at the end of day 1, you're figuring out what you have to do and change strategy for day 2 based on what happened in day 1. Maybe the judge said something. Maybe the witness said something that wasn't expected. maybe a piece of evidence got in that you didn't think would get in, or maybe a piece of evidence stayed out that you thought was going to come in, and now you don't have to deal with that evidence.
Yeah.
A lot going on, but it is a momentum, highs and lows, and you just got to stay in the game.
I love it. I love it. And I love that we're going to start there next time. You're right. How many episodes are we going to have on trial? I don't know. It could be 7.
But here's the thing. The judge doesn't get to make his ruling until the trial is over.
Mm-hmm.
And if we never want to hear from Andy, we got to just keep the trial going.
We got to keep playing the game. I think I already learned that. I learned that. This has been great. Don't forget, we've got questions. Head over to howtosplitatoaster.com and click that Ask a Question button. Submit your questions. We do have, I don't know, if Andy will let us, we'll have another Q&A episode coming up toward the end of the season after we wrap up our trial. More questions have been coming in, Seth, and they're good. So I can't wait to get to another Q&A episode. Keep that coming. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll see you next time for part 2 on trial, right here on How to Split a Toaster, a divorce podcast about saving your relationships.